Good morning, everyone, and welcome. I'm Chris Lyons, the CEO of the Food Production Solutions Association. We're really glad to have you with us today. Today's session is actually part one of a two-part series on tariffs and trade that we are presenting to our members and other folks who are interested in this issue. Our goal here is very simple. We're trying to help you understand what's actually going on with these issues right now and what it might mean for your business. As I think everybody realizes, tariffs are shifting in real time. There's issues with legal decisions, there's policy changes, there's global dynamics, there's an awful lot to keep up with. So today is trying to cut through some of that noise and focus on what matters most right now, where things stand, what actions you can take, and where the risks and opportunities are. So I'm pleased to introduce Courtney O'Toole Morgan. She's a partner at Hush Blackwell. Courtney leads their international trade and supply chain practice, and she works closely with companies navigating exactly these types of challenges today, from compliance and enforcement to real-world supply chain decisions. She brings both a legal and a practical lens to the topic, which is exactly what we need in a conversation like this. Just want to make a quick housekeeping note. We welcome your questions. We hope you put questions into chat, but we will hold off entertaining those questions until the end so we can get through the material and then spend time discussing your questions. So with that, Courtney, I'll turn it over to you.
Thanks, Chris. Thanks, everyone, for your time today. I'm going to go ahead and put my slides up for everyone to see. All right. So good morning, everyone. Great to be with you. I know this is part of a two-part series, so lots of information to share with all of you. But as Chris alluded to, I'm going to give sort of an overview of the state of play for tariffs and trade at the moment. I'm going to provide a legal update on what's going on with tariffs. We've had it's been fast and furious over the last year since President Trump's second administration. Part of my practice is obviously imports and tariff-related issues, but I also do a fair amount of work on the export controls side and sanctions side. And I like to think that tariffs have become the new sanctions. They really are the biggest issue we're dealing with on the trade and supply chain side. We'll talk about some compliance considerations and then some next steps for those of you that are dealing with imports. And at the end, we'll take any questions. So I wanted to take a step back. I'm going to talk about the Supreme Court decision that came out in February, but just taking a step back, setting the landscape for tariffs. We have a number of different acronyms, a number of different tariffs that the administration has imposed. I don't want to assume that everybody is familiar with all of them. So first, we have what were called the IEEPA tariffs. Those are under the International Emergency Economic Powers Act, or IEEPA. For those of you that are familiar with export controls or sanctions, IEEPA is a statute that has been used for many years, dating back to the 70s, to implement the majority of our sanctions and export control regulations. In 2025, it was used by the president, or 2026, sorry, to begin imposing tariffs under IEEPA to deal with issues of trade imbalance and national security. In addition to the IEEPA tariffs, we also have Section 232 tariffs. We have Section 122 tariffs, and we also have Section 301 tariffs. Section 301 tariffs date back to the first Trump administration. Those are the tariffs against China, imports coming from China. Those date back to 2018, 2019, and are still in effect. But in addition to those, we now have Section 232, Section 122, and these IEEPA tariffs. So in February, even earlier this year, as soon as the IEEPA tariffs were implemented, there was a case brought at the Court of International Trade. For those that aren't familiar, the Court of International Trade is the district level court that all challenges to trade legislation go to. The Court of International Trade's in New York. And two plaintiffs. So Learning Resources was one case. There's another case, VOS. Both of them, importers, brought a case before the Court of International Trade challenging the validity of the tariffs. There was a positive decision or an affirmative decision where the Court of International Trade ruled and struck down the tariffs. They not only struck down the tariffs, they also did something really novel in that they afforded relief to all importers, not only to the plaintiffs in the litigation. The case was then appealed to the Court of Appeals for the Federal Circuit in Washington, D.C. The Federal Circuit upheld the decision, striking down the tariffs, but they questioned whether the Court of International Trade had the authority to provide broad relief to all importers, or whether the decision should only be limited to the importers at issue in that case. The case then was appealed to the Supreme Court. The Supreme Court did entertain the case, entertained oral arguments, and on February 20th, the court ruled in a 6-3 decision that the IEEPA statute, or that the tariffs were unlawful and that they violated IEEPA. As a result of that, on February 24th, the administration stopped collecting for any imports after February 24th, stopped collecting IEEPA tariffs. But the question now remains how importers can go about getting refunds. Something to keep in mind is there is still this open question of whether the case applies relief to all importers. And so we're waiting. Currently, there's as soon as the decision was issued, the case went back to the Federal Circuit because the only issue that the Supreme Court really ruled on was the validity of the tariffs. They struck down the tariffs, but they did not opine at all in terms of how refunds should be processed, whether they should be processed for all importers, and whether the relief was universal. So the case went back to the Federal Circuit. The Federal Circuit, in turn, sent the case back to the Court of International Trade for the court to address this issue of who refunds apply to and how they would be processed. At that time, the case was assigned to Judge Eaton, who's one of the judges at the Court of International Trade. The chief judge assigned the case specifically to Judge Eaton, and he designated a lead case. It's called Atmos Filtration. And with that, he started issuing orders to customs requiring that they issue refunds. There is still this open issue of whether the relief can be applied to all importers. It's an open question that many of us on the trade side, trade lawyers, are wondering whether the government will actually appeal, because several orders have now been issued by Judge Eaton asking or requiring customs to start issuing and putting together a refund system. So just going over a little bit of the timeline, as I mentioned, there was a lead case designated, Atmos Filtration. As many of you have probably heard in the news, there's thousands of complaints that have now been filed at the Court of International Trade. The reason those complaints are being filed is importers want to stake their claim and make sure they have their own individual relief in the event the decision is not upheld to have nationwide application and application to all importers. So Atmos Filtration was designated as the lead case. On March 4th, that's when Judge Eaton issued an order to customs instructing them to refund all previously paid IEEPA duties. So in that order, the judge required that customs issue refunds relating to unliquidated entries and liquidated entries. A little bit sort of stepping back for a second in terms of processing entries, when you enter goods into the United States, there's a period of time where those entries remain open with customs. It's when entries are unliquidated. When an entry liquidates, it becomes closed or final in customs mind. And so the standard liquidation period is 314 days for customs purposes. So during that 314-day period, customs can ask any questions, can ask you to correct an entry. There can be back and forth. So customs, Judge Eaton instructed customs to issue refunds for any unliquidated entries. So those would be entries within that 314-day period. And he also requested that they issue refunds for any entries that are liquidated plus 90 days. That's what's called the liquidated but not final period. After 90 days, there's a period between 90 and 180 days when importers can protest and can administratively challenge their entries. Past that 90-day point, those entries were not initially addressed in Judge Eaton's order. On March 6th, Customs filed a declaration. So there's been a lot of back and forth over the last month where Customs has been issuing status reports and telling Judge Eaton what they can and can't do in terms of refunds. They are in the process of standing up a refund system. We'll get to a little bit more of that later. But they issued a status report on March 6th indicating that they would need 45 days, or they anticipated 45 days to stand up this program. On March 27th, the court issued another order. They amended their original order to cover 3 buckets of entries. So I alluded to the first one, unliquidated entries. Those are entries within the 314-day period. Then the order also addresses liquidated but not final. So those are entries that are liquidated, but within 90 days of liquidation. And then the third category that Judge Eaton added was finally liquidated entries. So those are entries outside of liquidation plus 90 days. The order that the amended order was intended to cover all IEEPA tariffs to ensure that importers get refunds of all of IEEPA tariffs paid. On March 31st, Customs filed another status report or declaration, and they gave more detail on their CAPE system, and a little bit an update on the progress and the limitations to the system. Again, I'll get to that in a second. And our next status report is set to come out today. So you'll likely see more. We're giving updates on our website, but also many others. You'll see reports in the news about what the status of where things are. Notably, Customs has also set up a website where they have specific information on the CAPE system. Their last report indicated that they hope to launch the system next Monday, April 20th. We'll see whether today we should know more about whether they're still moving in that direction or if they're going to need additional time. But the goal is to get that system and to open it up on April 20th. So I wanted to give everyone a little bit of information about the CAPE system and where we stand with it. For everyone's back, CAPE stands for the Consolidated Administration and Processing of Entries. Customs loves acronyms, so this is another one. Important to keep in mind, when Customs has described the CAPE system, there are 2 phases. Phase 1, the one that hopefully will launch on April 20th, there are certain entries that will not be included in phase 1. I like to think that phase 1 is going to cover the low-hanging fruit, the ones that are most, the easiest entries for Customs to process. They will not, in phase 1, they will not include entries flagged for reconciliation. Any entries that you're claiming drawback on or that are designated on a drawback claim. Any entries that are subject to an open protest will not be covered. Entries not filed in ACE. Entries without a liquidation status. Entries that are subject to anti-dumping and countervailing duties. And then any finally liquidated entries. So the only entries that will be covered in phase 1 are unliquidated entries. So entries within that 314-day period and entries that are liquidated post 314 plus 90 days. But notably, Customs has indicated that they've even shortened that 90-day period to 80 days because they need additional processing time. So the entries that will be covered by phase 1 are unliquidated entries, liquidated plus 80 days. And then you have to look at each of these other carve-outs, right? If you're an importer that claims reconciliation or flags your entries for reconciliation, they are not going to be processed in phase 1. If you pay anti-dumping duties on any of your entries, those entries are not going to be eligible for phase 1. If you claim drawback, if you have a protest on your entries, all of those will be handled at phase 2 or sometime in the future. Some action items for what importers can do right now to get ready. You want to be monitoring your entries, talk with your broker. if you have access to your entries through ACE yourself, monitor your entries. We're instructing companies to monitor the entries, pull together a list, identify what the liquidation date or the estimated liquidation date is, so you can figure out which entries are in phase one and which ones will go to phase two. You want to identify what IEPA duties have been paid and what the liquidation date is, because again, that's going to trigger whether you fall in phase one or phase two. You want to make sure that you're signed up for ACE. Customs has indicated the only way to participate in the CAPE system and to file for your refund is to file it through ACE. That's the only point of contact. That's the only way they're going to receive reports. So if you're not signed up for ACE, you need to get on that quickly. Customs is also only going to issue refunds electronically, so they won't be issuing paper checks. You need to sign up for ACH, the automated clearinghouse, and you can do that through your ACE account. So we've talked to many companies in the last few weeks, and I know there's a big backlog with Customs to get signed up for ACE. So if you haven't done that already, I really strongly encourage everyone to get on that, because it's taking quite a bit of time. Something else you can consider is filing a complaint with the Court of International Trade. Last I checked, I believe there's only over 3,500 complaints that have been filed with the court. That's for companies that are importers that are trying to preserve their individual right to refunds. There is a 2-year statute of limitations, so you do not need to file today. It's 2 years from the date harm was incurred. So the date you should be keeping in mind is the date the IEPA tariffs took effect. So the statute of limitations would be to file a complaint before January 31st, 2027. So there is still time to file. The consideration, different considerations of whether you want to file or not, but it's something to keep in mind that there is this open issue that we anticipate that the government may challenge Judge Eaton's orders and may try to limit relief to only the importers in the VOS and the learning resources case. And if that is the case, then individual importers will need their own right to relief. You also want to continue to monitor the litigation and see if anything is appealed, but also more so monitor the CAPE system and the rollout. Again, there's a status report due today. Hopefully we'll know more after that, but you really want to monitor Customs website, the CSMS messages, and see what Customs is doing and see if there's any delays or if things are moving forward. Because if it does really launch next Monday, there's going to be a rush from many people filing these complaints, or I apologize, not filing complaints, filing reports and refund requests. So moving on, I wanted to provide some information about the other tariffs. Now that IEPA has been struck down, we have a number of other tariffs that are still in place. As soon as IEPA, the government stopped collecting IEPA tariffs on February 24th, they quickly replaced that with Section 122 tariffs, which relate to a temporary import surcharge. This replaced the IEPA tariffs, took effect February 24th, and there is an in-transit exception. Those tariffs are 10% on all goods imported into the United States from all countries. The 122 tariffs can go as high as 15%, and the president has in several Truth Social posts indicated an intent to move to 15%, but nothing has been confirmed yet. So for now, the tariffs are 10%. They currently run through July 24th, 2026. Under Section 122, these tariffs are limited to 150 days in application. At that point, as of July 24th, the president would need to seek congressional approval for an extension. And I think such an extension is pretty unlikely. So I think the administration has other devices and other tariffs in mind, which we'll get to, which will likely replace 122 in July. Some exemptions that apply to the Section 122 tariffs are listed on the right. Critical minerals, electronics, natural resources, and fertilizers. All of these are items that are currently being reviewed under potential Section 232 investigations. Pharmaceuticals and pharmaceutical ingredients, those were announced about 2 weeks ago. The president is pursuing 232 tariffs. for pharmaceutical and pharmaceutical ingredients. Similarly, passenger vehicles, light trucks, there are 232 tariffs, auto tariffs, and truck tariffs that are in place. So if you're subject to those tariffs under 232, you are not subject to 122. Also, goods that qualify as USMCA qualifying, US, Mexico, and Canada free trade agreement. If you have goods that qualify under that free trade agreement, they're exempt from 122 tariffs. In addition to the 122 tariffs, we have Section 232 tariffs. There's, as I mentioned before, there are a number of different sectors that the 232 tariffs apply to or have been forecasted to apply to. But the ones that have really been with us for, a number of years now, dating back to the first Trump administration, are the tariffs on metals, specifically on steel and aluminum. These tariffs have gone up and down, went from 25% up to 50%. But on April 2nd, the president issued a proclamation making changes and revising the metal tariffs. Some important things to note: there's now a flat 50% Section 232 rate on steel, aluminum, and copper. These are articles that fall in Chapter 72, and some goods in Chapters 73, 74, and 76. Within these new metal tariffs, and in the proclamation, there were 4 different annexes. Annex 1A covers the items that are subject to the 50% flat tariff. There are also Annex 1B talks about covers goods that are subject to a 25% Section 232 tariff. Those are for steel, aluminum, and copper derivatives. So prior to this April 2nd proclamation, we had tariffs on steel and aluminum. You had steel and aluminum articles where the tariff was subject to the full value of the goods. And then you had steel and aluminum derivatives. If the item was on the steel, the aluminum or steel derivatives list, the tariff was only applied to the steel or the aluminum content in those articles, and not to. And then on the remainder of the value, you would pay the IEEPA tariffs or the 122 tariffs. But as of April 2nd, with this new proclamation, the administration has changed course, and instead is applying a flat rate to the full value of the good. So for those in 72, 73, 74, 76, you're subject to a 50% rate on those listed items for the full value of the good. If you're on the steel, aluminum, or copper derivatives list on Annex 1B, those goods are now subject to a 25% tariff on the full value of the item. So that's a big change. There's also been removal of certain derivative articles. For those of you that are familiar with these tariffs, there were a number of items that were captured that had very, very little metal content, maybe a small amount of aluminum, small amount of steel. Several items have been removed from the derivative products list, and those are listed in Annex 2. So you really want to take a look at each of these annexes and figure out for your products if any of them are on these annexes and which ones. If they're on Annex 2, they've now been removed from the derivative list, so they're no longer subject to 232 duties. Annex 3 also covers a 15% flat rate. The 15% rate is for most favored nation, column 1 countries, and those rates run through December 31st, 2027. There's also a new de minimis requirement for products that do not contain 15% or more of metal are no longer subject to the 232 duties. So this is done by weight. You'll want to look at, it has to be products outside of chapters 72, 73, 74, and 76. So those are really steel and aluminum items. For those outside of those categories, and if they're listed in Annex 4, and it's a 3-part test. If they're not listed in those categories, if they're not listed, and they're listed on Annex 4, and they do not contain 15% or more by weight of metal, then they're no longer subject to the 232 duties. That's something we're getting a lot of questions about. And you need to remember it's a 3-part test. You need all 3 parts to qualify. And so that's something to look at closely and look at your products. There's no longer, prior to this, in the previous metal tariffs, there was a process where U.S. companies could submit comments and potentially add new items to the list. That process has gone away. So there's no longer an inclusion process. And the new tariffs or the revised tariffs do allow for manufacturing drawback, and they also allow for Chapter 98 imports. So if you're bringing goods in under various duty deferral programs, whether it's U.S. goods returned, if it's the Nairobi Protocol, so for goods that are for handicapped or disabled or ADA compliant type of goods, if those qualify under the Nairobi Protocol and are allow for that exemption. If you bring agricultural products for agricultural use, those Chapter 98 products can still come in without payment of the tariff. But again, those are all very specific use provisions. So you want to make sure and check with counsel or check with your broker as to whether they actually fit your scenario and your situation. An important caveat or thing to keep in mind is that these lists are changing and subject to change. Any changes will be published in the Federal Register, so it's important to keep up to date and to continue to check. You also want to check in the HTS, the Harmonized Tariff Code, because the changes are being made in real time. So before we move on from 232, I just wanted to flag there is a pending case right now, Express Fasteners. So prior to April 2nd, as I mentioned, there were these two applications of the metal tariffs. You had goods that were steel articles, aluminum articles that were subject to full tariff on the full value of the item. But if you had a steel or aluminum derivative article, those goods, the customs instructions were to pay tariff only on the steel content or the aluminum content, the value of the steel content and the value of the aluminum content in those derivative products. There's a case that was brought at the Court of International Trade challenging some recent enforcement actions by Customs. Customs has been enforcing and asking importers questions about how they actually valued the steel cost and the non-steel cost. So Customs has been issuing informal or individual importer instructions about not only including the steel content, but including other non-steel costs related to fabrication, machining, factory overhead. And that has not come out in official guidance from Customs directly to importers. So Express Fasteners was a case where they protested, had their protest denied, and they're challenging Customs determination that these goods were subject to including non-steel costs in the value. This relates to goods prior to April 2nd, because right now we have a new strategy or new, now it's on the full value, so it's not a consideration anymore. But there are still several and numerous entries and a whole months and months of entries that have this potential issue. So we're watching the case to see what happens and to see, if Customs revisits this at all. I mentioned Section 301. There were two new cases, two investigations launched on March 12th. The first one affects 16 countries, and it relates to structural excess capacity and production and global manufacturing. It targets a number of different industries, including steel, aluminum, semiconductors, and electric vehicles. It was just launched March 12th. And then there was a second investigation launched the same day against 60 different countries. This is focused on forced labor practices. Not that the administration is not focusing on these countries necessarily having or harboring forced labor, more that they're sourcing goods that may be procured with forced labor. So both of those investigations just kicked off March 12th. Comments are due April 15th tomorrow, and there's going to be a hearing at the end of April. So comments are due tomorrow, as well as requests to participate in the hearing for any importers that are interested in participating. Those are due by tomorrow, and the hearing again will be April 28th. What we're anticipating is that, and what USTR Greer has indicated, is that their hope is to process and to conclude these investigations prior to the 122 tariffs expiring. Those are set to expire July 24th. So we expect one or both of these investigations to move quickly so that these 301 tariffs can take the place of the Section 122 tariffs when they expire. So I wanted to just quickly go over some compliance considerations for everyone to keep in mind, some best practices and some issues that we've seen over the last few months and year. We know that importers are very interested in how they can mitigate tariffs because unfortunately it doesn't seem that they're going away. So some things to keep in mind and best practices. Obviously, all of these tariffs are driven by harmonized tariff code. So it's really critical that you take some time to assess your harmonized tariff classifications to make sure that they're accurate. Also, it may present an opportunity where goods may have been classified, more generically, or there may be a more specific classification or a more appropriate classification. So that's something to take a look at. You also want to take a look at your entered value. Obviously, tariff is levied based on duties, and tariffs are levied based on the value of your goods coming into the U.S. So there may be opportunities for non-dutiable charges for certain charges that you've been including that don't need to be included. Some companies have been looking at the first sale program. They've been looking at related party pricing. These are things just to definitely with a customs professional, I would suggest don't, do the, unless you have internal capabilities that have experience with valuation and strategies, you may want to talk to outside consultants, to your broker, definitely to customs counsel before you make any changes. But those are considerations that people are keeping in mind. Also, the tariffs are driven by country of origin. So looking at your country of origin, making sure that you've done the proper analysis. If you are claiming USMCA preference and it's helping, exclude on the 122 tariffs or previously on IEEPA tariffs, there is a lot of enforcement going on by customs right now in all three of these areas: origin, value, and classification. So it presents opportunities, but you also want to be mindful that you have the documentation to support all of these preference claims. So definitely things to look into, but also make sure that you have the proper record keeping and proper paperwork. Something else to do is review your terms of sale. What Incoterms do you use? If you're purchasing on an FOB basis, do you want to potentially move to DDP, move to something where you have less exposure as an importer, or maybe in the other direction where you want more control over your supply chain and more leverage? So definitely looking at the Incoterms, making sure that they're proper for what your business wants and how you want to structure your transactions, but also limiting your risk as much as possible. You also want to review supply agreements and purchase order terms and conditions. Something we're hearing a lot about now, given with tariff refunds, is reviewing whether you're in a vendor situation or if you're the customer. If you're the customer and your vendor was charging a tariff surcharge, if you had anything in your supply agreement about tariff refunds, those are things to definitely take a look at now as the refund process is kicking off. Also looking at any preferential programs. So drawback, is there any opportunity for you to get a refund on any of the tariffs paid if you're sending goods out of the U.S.? So if you're importing goods and exporting similar goods out of the U.S., that's a program you might consider. Also, Chapter 98. Chapter 98 has several provisions for either duty deferral or duty relief. So those are provisions you might want to consider. And finally, monitoring the refund program and monitoring the tariff litigation to see if anything changes and if there's any limitation on what importers can and can't receive in terms of refunds. Some best practices, just thinking forward about, we've been seeing a lot of enforcement. I had mentioned before, taking a look at your classification, evaluation at country of origin. It's important to keep in mind that there's a 5-year statute of limitations for entries. So if you do, dig into your classification, discover that there's a classification that may be more proper, and it provides tariff relief, before you make that change, you really want to think long and hard and really evaluate how to proceed, because there is a 5-year statute of limitations where customs, you're expected to go back and correct your entries, or customs can come to you and ask about it, and you could have potential penalty situations. So sometimes while making a change going forward seems like the right approach, you may be buying yourself a problem looking back 5 years. So you really want to be thoughtful about it, and figure out what's best for you and your business. Harmonized tariff codes drive your duty rate and admissibility of your products. So something to keep in mind, the harmonized tariff code is really, really critical, especially with each of these tariffs that are driven by that. There's a lot of scrutiny right now on country of origin claims, because they are providing some tariff relief. So definitely make sure you have the paperwork to support those claims. We're seeing a lot of CF-28, so requests for information from customs, where they're asking a lot of questions about origin and how you substantiate origin. And I think I covered most of this. The 5-year statute of limitations is something really important to keep in mind. Something else to keep in mind, there are transshipment penalties. I haven't seen a ton of enforcement with this, but there always is the potential. The president had indicated and announced that they're on top of the current tariffs and duty. If it's found that your products, say you have goods from China, but you're sourcing them from Malaysia, and customs can determine that the goods were actually transshipped, so they're not actually Malaysian origin. They're being, obfuscated or improperly designated. The origins being improperly designated. You could be subject to transshipment penalties, and those penalties go on top of the other tariff that you would be subject to, so they can be significant. CBP is looking closely at any changes that you make in your classification value and country of origin, because all of those drive the tariff revenue. Customs does a lot of data mining. They look at entries very closely. If you're making changes to your entries, that triggers sometimes a mini audit. So something to keep in mind when it seems very simple and very perfunctory to just make a correction to an entry and change something if the classification's wrong, the value's wrong. But that's also what we're seeing is it's triggering bigger, more focused reviews for customs. So it's something to definitely evaluate with your broker, with counsel, with a consultant to make sure you're taking the best approach to limit your risk. Records and compliance best practices are really important. They're really going to help you in any type of enforcement situation if you're trying to limit any penalty exposure. And finally, there's a task force that was stood up by the Department of Justice earlier this year. They've repurposed a group that had been focused on SEC-related enforcement, and now they're focusing on trade fraud and evasion. Obviously, there's a lot of money at stake with regard to tariff revenue. And so the administration's very focused on enforcement, and making sure that any of these issues we talked about are that goods aren't being improperly designated with improper origin, improper classification, any type of situations like that. So you want to be mindful of making any big changes. And as I like to say, anything that's too good to be true is often too good to be true. So something to keep in mind. I also just wanted to provide everyone, in terms of next steps, some resources you can consult for staying up to date. The information changes daily. We have another status report coming out today, so it's very hard to keep on top of it. But our firm does a blog that's a free resource available to all of you. It's called International Trade Insights. We follow all of the agencies that are trade focused, so Customs, Commerce, and Treasury, and we're seeing everything that comes out. So feel free to avail yourself of those resources, but also other public resources. The White House, whitehouse.gov is a critical website because any proclamations, any fact sheets on tariffs are coming out through their website. So definitely subscribe there. Also consider subscribing to the CSMS, which is the Cargo Security Messaging Service. That's a service that Customs provides, that they issue messages to brokers and to the trade. They've issued a number of messages already. Every time any of the tariffs are changed, they issue notices. They're issuing notices on the CAPE system, so definitely consider subscribing to that. Also, Commerce and Department of Justice have mailing lists. And finally, you want to follow the president's social media posts. But something to definitely, all of you probably know this, but just keep in mind, just because it appears in a social media post does not mean that it's official, and that it's, while the president may have tweeted it or put it in a social media post, I would definitely wait for the proclamation. Wait for the proclamation or the fact sheet executive order to come out from the White House before anything actually goes live and makes changes. And finally, there's just a QR code here if you want to subscribe to our blog. We also do a monthly newsletter, a trade law update, and that's available on our website as well. So happy to take any questions.
I have a question. This is Chris. There we go. There's my video. It wouldn't come on. You mentioned earlier when we were talking about IEPA that there's 3,500, if I have this correct, 3,500 claims already logged for tariff refunds. And then there's the question that's out there, will the ruling be that any importer is able to receive a refund, or do you have to file these individual claims? Two-part question. First of all, any wild guesses as to the total number of importers who might be able to file individual claims? I mean, we're at 3,500 already. Is the number a five-figure number somewhere of how many could file individual claims? And the second thing is, does the magnitude of those claims building, the magnitude of individual claims, does that impact the eventual decision where the courts will say, like, look how many are waiting out there as individual claims, might as well just make it a blanket, anybody can get a refund?
Yeah, I think there's a couple of different dynamics at play. I think Customs realizes that the tariffs were struck down, and at some point, refunds are going to have to be issued, right? So they are standing up the system that needs to be done to process this. And I think at the same time, we know, I think the number I had seen was there's $160 billion of refunds to be issued. I think that's why you're seeing there's a phase one and a phase two, because phase one is only going to cover a limited number of entries. And I think that we'll see how long it takes to get phase two actually up and running. To your question on the complaints, 3,500 complaints could mean, I don't know the actual number, but I know in our case, when we file complaints, it's often for 5 or 6 importers, right? So that number is even higher, right? It's probably thousands of importers, but the actual number of importers, I think Customs has given some statistics that there are 30 or 30,000 importers out there, something like that. So those are the different parties that, if they haven't filed, they're going to be filing these reports with Customs to get refunds. So if it goes live on April 20th, if it goes on, best case, it goes live next Monday, 30,000 importers trying to file for these refunds.
Harder than trying to get a concert ticket to a good concert.
I think I imagine there's going to be system issues and right. So we'll have to see how it works out. But I think there does remain this legal issue of whether these orders that Judge Eaton issued when there's a lot of mechanics that's gone on that would probably bore everybody else, but there was a lead case that was designated. That case That case, the importer of that case did not want to carry water for all of these different importers. So they actually voluntarily dismissed their case, and now a new case has been designated.
Yeah.
So there's a lot of, from a trade lawyer perspective, there's a number of issues procedurally that the government could latch onto and could try to slow this down. So I think the reason you see so many companies filing these complaints is they don't want their entries to time out, right? They want to be able to preserve their right. This could take years before the actual refunds happen. I hope it's not that. I hope it's much quicker, but they want to make sure they're preserving their right. So
there's a couple other good questions, but I've got one quickie.
Yeah.
If I'm getting a refund, is there an interest given on the amount of money? Okay.
Yeah, you
Wow.
should get it should be the tariff paid plus interest to the date back to the date you paid it.
Okay. So there's a question about 301 investigations, a little clarification as to what those investigations are about and why those are occurring. If you could just reiterate that again.
Yeah, so I can't say we know a ton about the Section 3. There was an announcement, there was a Federal Register notice. One is relating to, they call it structural excess capacity. So the current 122 tariffs relate to, and there is a pending court case. There was oral argument last week. I apologize, I didn't mention that. But on the 122 tariffs, those are currently being challenged at the Court of International Trade because the 122, the specific provision relates to imposing tariffs to resolve a balance of payments issue. So there's a question of whether legally this trade imbalance is really a balance of payments issue. Regardless, those tariffs time out in July. So the government needs something new to replace those tariffs. We anticipate that the 2301 investigations are going to cover what the 122 tariffs were. One of them covers this structural excess capacity. So foreign countries having excess capacity of their goods and selling them in the U.S. market, right? And flooding the U.S. market. The other case is forced labor related.
Yeah.
Not a lot there, except for what it seems to be the argument is that they're alleging that foreign countries are sourcing goods or products from China, like the Uyghur region, from products that are made with forced labor. And so it's not that Europe or whatever country actually has forced labor. It's that they're sourcing materials that are made with forced labor.
So if the investigations turn out to say, yes, this is actually occurring, they give a reason for additional tariffs to be put on.
Yes. Okay. And notably with 301 tariffs have been upheld, right? We've challenged them legally before. They've been upheld by the courts. So the reason there's a little more like taking a step back, there's a menu of options that the president had available to him for tariffs. I think he went to IEEPA first because there was no ceiling, right? And it could be implemented very quickly. But 301 is one that's already been challenged in the courts and is going to stand up. Right. And so as long as they conduct an investigation, but the problem is they can't implement it immediately. They have to go through notice and comment. They have to go through a hearing.
Sure. There's also a question about filing for ACE. Is there assistance available for companies like your own firm to help people do those filings?
Yeah. So in order to sign up for ACE, the importer has to do you can only do the importer or their broker. What we can help with, so we as a firm, we have an ACE account and we can help file protests, things like that, but we cannot, like a company, we can give you some help in terms of the mechanics of it, but you as an importer have to sign up for your own ACE account. You can also check with your broker can go into ACE for you, but really as an importer, you should be setting up your own account because that's the way you're going to have to apply for the refund.
And have you talked to anybody recently, like how backed up is it to get one for your own company?
I talked to someone yesterday that the biggest issue is it's trying to set it up and then you have questions. And if you try to contact their helpline, it takes forever for them to get back to you. But I think it's taking, 1 to 2 weeks for them to process your account.
That sounds optimistic.
Set it up.
Okay. Yeah.
It's better. Yeah.
Yeah. Uh, there's also a question, I'm not sure whether this is kind of in your wheelhouse, but an accounting question. I mean, are companies
Mhm.
booking these potential refunds, or how are they, in their own accounting dealing with it, the uncertainty?
Yeah, I would think. I mean, it's the answer. I don't know, but I think that's definitely a consideration as we're moving into the second quarter, right? And you want to. We have had a number of questions from clients asking when do we think the refunds will happen because they're trying to figure out is it this year versus next year, um, and I think maybe we'll know a little bit more later this week if we see where customs is. But I would be surprised if people get these. I think best case would be the end of this year. Um, I don't see them being in the next month or two. So if that helps, but I would definitely check with your accounting folks because there's terminology that I as a lawyer am not familiar with, like in terms of what is what they have to what the different definitions are in terms of what you declare and don't declare. So definitely check with your accounting folks.
And you had mentioned USMCA also
Mhm.
earlier in one of your slides. If your imports and exports, Mexico, Canada, are covered under that, does that kind of protect you from all these others? Is that like you can't be touched because you're already under that? Is that how it works?
It's certain tariffs. So for if your goods are USMCA qualifying, you're excluded. You're exempt from the 122 tariffs. You were exempt from IEPA, but those expired in February. So 122 IEPA, you are not 232 is not exempt. So if even if your goods are USMCA qualifying, if your goods are on the 232 list, you're still subject to the tariffs.
Wow.
So you really need to look at which list you're on and which tariffs you're subject to.
Wow.
So
If there's any takeaway from today, this is crazy complicated and
mhm.
all the pieces keep moving. It's just really amazing. Is there any other question? Here's something just came in. I have read that the unliquidated entries will liquidate without IEPA tariffs, and the refund would be issued for that entry at that time. Do you have any info on this?
I have not seen anything about. And my understanding is you have to request because there's going to be a process that I didn't get into all the details, but the CAPE process is a 4-part process, right? Where you submit a report. I think something else we should talk about. There's some misnomers or information out there. Customs has posted a 45-day time period. The 45-day time period is only after you submit a report to customs, they validate it and come back to you and you go back and forth. It's kind of like you put your tax return in and then they validate it and they come back, and once they say it's okay, then they have 45 days to process, right? But my concern is you could end up having back and forth for 6 months, right? By the time they actually get to your report. So you need to submit a report. The importer needs to submit a report through this CAPE system to apply for your refund. I haven't seen anything to indicate that they're automatically going to refund you.
Wow.
Um,
Okay.
so
And there's also a question about anticipating the time. When do you anticipate phase two going live?
I don't know. I, to me, I think that's, yeah, I think we don't know yet. So I think they'll probably see how phase one goes and see how quickly they can process things. Because phase two is a lot more complicated. Phase two is all of the entries that have different issues, right? Have different programs and different, so they really need to figure out the functionality. Um, so maybe later this year, but I really have no sense, unfortunately.
And if the administration appeals for any of these, that can slow it down even further, right?
Yeah, and the date to keep in mind for right now is June 6th is the so when the case was when Atmos decided to withdraw, the court designated a new lead case which is called Euro Nations, and that was April 4th. So you have 60 days from April 4th for the government to appeal or to appeal those orders. So June 6th would be the next date we're looking to see if the government is going to appeal those orders.
All right. Any further questions? I think we're kind of at the bottom of our time here on this. Any last takers? I want to remind everybody, if you haven't taken a look at the chat, there's a link in there to get the slides from today's presentation. I just want to thank you, Courtney. This has been super interesting. It's kind of making my head spin, but you know,
Welcome to the
that
club.
keeps you in business, I guess. I don't
Yeah.
know. But it was incredibly helpful. And I think this is the kind of information and I don't want to say clarity, but beginning to make sense of what's happening, right? That our
Yeah.
members need and also folks in our industry because it sure is murky from the outside as to what the heck's happening and what do people do. So, you know, this is very complicated, constantly changing, and you really help kind of lay it out as to what's going on here. I just want to make everybody aware that this is part one of a two-part series. We're going to pick up this topic again tomorrow, part two, which is about trade policy, the trade policy playbook. So we're going to shift from kind of where things stand today tactically. We've been listening to a lot of things that you ought to do, things you ought to be keeping in order and actions you can take, right? To looking forward to what are the policy trends, what's going on in this area globally also, and what you should be watching for the rest of this year. So if today helped you get grounded kind of in what you should be doing, tomorrow's about helping you look ahead, maybe a little more proactively. So we'll take a look there. I would strongly encourage you all to join us again tomorrow, same bat time, 11:30, and to listen to part two. So thank you very much. And if you're enjoying these webinars, of course, FPSA has a full calendar of webinars going on throughout the year. I encourage you to take a look at our website as well and take a look at those. So thank you again for joining us today. Thank you so much, Courtney. This has been super interesting.
Thank
I
you.
hope everybody has a good rest of your day. Take care.
You too. Thanks. Bye.